Welcome to today's episode of Alan Stands or Sits Next to Tall Things. Today, an old arsenic works. But why we're here? We're here to talk about the common law, because people keep asking, what exactly does that mean? Well, like so many things in English law, it has lots of different meanings in lots of different circumstances. So let's go back to near the beginning. 1066, William the Conqueror's just arrived, and he's won, and he wants to establish his authority across the realm. Because at the time, England was still very fragmented. There were lots of people vying for power. So for practical reasons, he wanted to establish just one set of laws across the country. But also there was an element of stamping his authority. So he sent out a commission called the General Eyre, E-Y-R-E. And their job was to just go around the country, see how people were doing things in various places and see if there's any good practice that they could adopt. But when they got, for instance, to the Danelaw, the area of the country still pretty much under control of the Vikings, the Vikings said, the Norse, because Viking is a job description, said, well, we quite like having our own laws, actually. Okay, fair enough, you can have your common law for some things, but, we'd rather, when it comes to local issues, we'd rather sort that out ourselves. The Norse word for a settlement is by, as in like Grimsby or Wetherby. So those local laws became known as bylaws, and that's why local authorities today can still set their own laws, so long as they don't conflict with the common law. But what do we mean by common law? I mean, that's one meaning, just law that is applicable across the entire realm. But generally speaking, we talk about being in a common law jurisdiction. And that's associated with things like it's an adversarial process. In other words, the judge is just the referee. Each side has their own lawyers, whether this is civil or criminal. They decide which witnesses to call, what evidence to present, what arguments to run. We also like things like juries. That's a common law tradition as opposed to the judges deciding. That's to be compared to a civil law system. Rather confusingly, a civil law system that can include both civil and criminal law. But that's what they have on the continent, for instance, or Code Napoleonic or Roman law, as they sometimes call it. So, in a civil law system, that's inquisitorial. The judge is in charge. The judge decides, what to investigate, what witnesses to call, what evidence we need to see. I mean, the parties can have lawyers, but it's very much under the control of the judge. We actually do have some civil law inquisitorial aspects over here. Inquests, for example, as the name suggests, inquest, inquiry, inquisition. The coroner acts more like you'd expect a European judge to act. They decide which witnesses to call, what evidence to hear, what the issues are. Also, some family law is inquisitorial because, kids are involved. And also in Scotland, because of their historical association with the French, they have a lot of civil law elements there. In civil law, unlike here where you go, right, let's look at the statute, but then in terms of interpreting it, let's look at what all previous judges have decided in previous cases. In civil law systems, you look at the code, everything's written down, and each court approaches that afresh for each particular case. They're not bound by precedent or the decisions of previous judges. I mean, as Heinlein once said, precedent is the idea that 200 years ago, a bunch of guys who know nothing about this are in the best place to decide what should happen now. So there is that conflict between certainty, in other words, we can predict what the outcome is going to be because the courts will follow the previous law, as opposed to tailor-making decisions to suit the justice and fairness of each individual case. So there you go. So that's one difference. Common law jurisdictions versus civil law jurisdictions. That brings us on to the next one, which is common law versus equity. Common law was very, very formulaic and, very rigid. Courts didn't have a lot of flexibility. So sometimes you'd get an outcome that wasn't fair. So influenced perhaps a little bit by the French way of doing it, people would go and say, well, hang on a second, this isn't fair. So they would appeal to the Chancellor as the conscience of the king and say, that was an unfair result, notwithstanding it was legally correct. Can you do something about it? And eventually you had a separate set of courts, the courts of equity, where if you'd had an unsuccessful case in the common law courts and you weren't very happy, you could have another go in the courts of equity, and they had a lot more flexible approach to things. In 1876 and 1878, something called the Judicature Acts actually abolished the separate equity courts and they merged them. So there's just one court system now. But the courts can consider both common law and equity. For instance, damages. That's the only common law remedy in a civil case. You can only get money. But what if you need like an injunction or a declaration or something like that? Well, that's you apply under equitable principles. And there's various maxims of equity. You know, you must come with clean hands. Equity follows the law. Equity will not act in vain. All this sort of thing. Well, I'll do a different video about that. So again, that's one. That's another use of common law versus equity. But when we come to interpreting statutes, again, we differentiate the statutory law and then there's common law. The statutory law is the Acts of Parliament, the black letter law. But the way the courts interpret that, we call that common law. So for instance, there's no actual Act of Parliament prohibiting murder. That's a common law offence. So an indictment will say, statement of offence, murder contrary to common law. Whereas some offences are statutory. So, you know, statement of offence, theft contrary to Section 1 of the Theft Act 1968. So there you go. So there's at least 3 separate meanings of common law, 4 if you include the general, it just applies everywhere. And also, rather confusingly, some different uses of civil law, because civil law can include criminal law. That also cropped up when I used to do courts martial, actually, because one of the offences you could be charged with was committing a civil offence, which just meant committing, you know, a regular crime as opposed to a military crime. So if you were done for theft, that's a civil offence because that's illegal for everybody. Whereas if you were done for like not shaving, that's just a military offence. But anyway, there you go. As always, hope you found that vaguely interesting. If you did, please consider clicking the like button, subscribing and sharing. Although, like I say, you know, no obligation to, because this is a nice excuse for me to come out to nice places like this and just ramble.